Welcome to our Curious Amalgam, the weekly podcast brought to you by the Antitrust Law section of the American Bar Association. Our Curious Amalgam explores the fascinating and increasingly overlapping world of competition, consumer protection, data protection, and privacy law. Each week, we bring you leading global experts on the most compelling issues of the day. Enjoy the show.
Hello and welcome to our Curious Amalgam, the podcast from the American Bar Association Antitrust Law section. My name is Anora Wang. Today's topic is, has the system derailed? The state of competition in the U.S. freight rail sector. Joining me today is my co-host, Barry Nigro. Hi, Barry.
Hi, Anora.
Who is our guest today?
So our guest today is Dr. Russell Pittman, the Director of Economic Research in the Antitrust Division of the U.S. Department of Justice and a visiting professor at the Kaye School of Economics. Dr. Pittman earned his PhD in economics from the University of Wisconsin in 1979 and has consulted regularly with antitrust enforcers and economic reformers in transition and developing economies. He's also acted as an advisor on railroad restructuring projects in Brazil, China, Mexico, Poland, and Russia. Some notable mentions include his service on the World Bank's core team for the World Development Report 2002, his service for the Russian Regulatory Reform Review carried out by the OECD and the European Conference of Ministers of Transport in 2003 and 4, and his service for a project of the OECD and the International Transport Forum on freight rail regulation in Mexico from 2016 to 2020. Dr. Pittman has also authored a number of relevant articles and book chapters, including a chapter on railways in the Oxford Handbook of the Russian Economy and a chapter on the U.S. in the Handbook on Rail Regulation, Concepts and Practice.
Great. Without further ado, Russell, welcome to the program.
Thank you very much. It's my pleasure to be here.
So, Russell, if it's okay with you, I'd like to structure our conversation in three buckets, starting with competition concerns, then taking a look at some recent competition challenges, and finally discussing some high-level observations. Is that okay with you?
Absolutely.
To start off, let's get a primer on the landscape of the U.S. freight rail sector. Who are the various participants in the market? And how does it all work? In particular, is there anything worth noting about the U.S. versus other places in the world in terms of how the freight rail system works, given that it's vertically integrated, as compared to places where the states own one set of tracks, like in the EU?
Well, to really start off, let me say that the views expressed are not necessarily those of the U.S. Department of Justice. Yes, the U.S. freight rail system, quite successful. It's really the envy of the world. The main companies are what's called the Class 1 railroads, which are in the West, the UP, Union Pacific, and the Burlington Northern Santa Fe. In the East, CSX and Norfolk Southern, and running right down the middle, the newly merged Kansas City Southern and Canadian Pacific that goes all the way from Vancouver to Mexico City.
Some have expressed concerns over a lack of competition in the freight rail market.
Russell, I think previously we wanted you to explain maybe who are the market participants. Maybe you can explain that first. Maybe like the owners of the tracks, the railroads and shippers, and how they work together.
Sure. As I mentioned, there are five main Class 1 railroads in the U.S. A sixth one that comes into the U.S. is the Canadian National. These railroads, like those in Canada, like those in a smaller country, Mexico, are vertically integrated. That is, they own their tracks, they run their trains on them. For the most part, they can decline anyone else's request to run trains on their own tracks. And that's different from the rest of the world. For example, the EC where the general model there is to have a monopoly track system owned by the state or a state-owned company, and then competition among freight train companies on that monopoly track. The big shippers in the U.S. are shipping coal and grain and bulk chemicals and construction materials like wood. There are a lot of other shippers like auto parts and autos. They tend to have more options for using, for example, trucks. Whereas a big coal shipper, there's just no way they could use trucks to ship all their coal.
People's concerns over a lack of competition in the U.S. freight rail. What are the specific concerns again?
Well, the interesting thing, and many of my international friends are surprised by this, is that the U.S. vertically integrated freight railway systems actually compete with each other directly in both what we call a parallel manner, in the sense that you have multiple choices now to go between, for example, California and Chicago. And you also have what we call geographic or source competition. That is, if you're shipping something from Chicago, you have multiple vertically integrated railways competing for your traffic, going in different directions. That's, again, pretty unique in the world in terms of all of those railways are vertically integrated. I would say the big success of the U.S. model is that because the freight railways own their infrastructure, they spend a lot of money, they invest their own money in it, whereas the rest of the world depends on the state to invest, and the state always has multiple demands on its money. The big difficulty now is that starting in the 90s, the regulator started approving mergers among the big systems to the point that now we have only basically duopolies serving most shippers at best. And unlike what the regulator believed when it allowed those mergers, it appears that those duopolies are not competing very hard against each other. The shippers are quite vocal in saying they're happy to live and let live and not try to poach each other's customers.
If the shippers' concerns about competition are valid, are there any remedies available?
Well, I would say, as far as I know, nobody is proposing to undo those mergers. They're, 25 and 30 years old. It would be very difficult to undo them. So there are many regulatory remedies that are proposed, which I would say are probably inadequate to restore the status quo, but may help. Probably the most important one, and the one that's gotten the most attention from the STB, is to require what's called reciprocal switching, which is...
What's the STB again?
The Surface Transportation Board is the successor to the Interstate Commerce Commission, and it is the regulator of the freight railways. And it has the authority to set rates under certain conditions. Most rates are set freely, partly on the theory that trucks compete very closely with rail, and indeed have taken away a lot of their business over the years. But in those cases where there is not effective competition for the shipper's business, in particular what's called captive shippers, the STB has the authority to try to create competition to regulate rates, or both. And I would say the two main areas now of activity are this business of reciprocal switching, which would force a railroad company that monopolizes a single shipper to give that shipper the option of ordering its traffic to be switched to a competitor at the nearest junction. That's number one. Number two, there is a lot of debate going on now as to the best way to regulate rates in those situations where there's a captive shipper with no alternative, and the STB wants to make sure that that shipper is protected from monopoly rates. And by the way, this exact debate is going on in Mexico with the newly created freight railroad regulator.
So the reciprocal switching obligation, that is that take the form of a rule that the STB has imposed?
It takes the form of a rule that the STB could impose, generally has not imposed. It's been holding hearings on it for years to see whether it should be more active in imposing this remedy. It recently moved away from the idea of imposing this remedy for competitive reasons, for direct competitive reasons, and imposing it for specific problems of poor service. That if a railroad is really getting poor service from its incumbent, the STB is now saying it may order switching so that a second railroad can compete for the business.
So is that a performance standard that triggers the possible reciprocal switching obligation? And if so, are there other standards that might apply and trigger the obligation?
It is a performance standard and a very detailed one, and I believe they're still asking for comments on their proposal for exactly what the performance standards would be that would evoke a switching order. In theory, the STB has always had the power to order switching for competitive reasons, but it got out of that business decades ago. It's been talking about getting back to it. The shippers would love it. The railroads would hate it. It's right now it has switched its attention to service issues rather than competitive issues. It could always return to competitive issues if it wanted to.
So do you have a view on the effectiveness of mandatory reciprocal switching? Do you think it's something that will work or not?
The problem is, I'm in favor of anything that would make it more likely for competition among these duopolists to break out. But the problem is that for reciprocal switching to work, the second railroad has to want the business, has to be willing to compete for the business. And what the shippers have been telling us is that ever since these mega mergers and combinations, the duopolists have not been interested in competing with each other. And so I fear that what has happened definitely in Mexico would happen in the U.S., that the second railroad would simply not be interested in giving a competitive offer. Anything that might increase the temptation to do so is probably a good idea.
So to better understand this space, which remains a partially regulated industry in the U.S., despite significant deregulation with the Staggers Act in 1980, we just want to understand a little better what are the regulators, and if there are multiple regulators, and what roles do they play. You already briefly mentioned STB. Is there any other in the U.S. that's regulating this space?
There's no other real economic regulator. The Federal Railroad Administration, which is part of the Department of Transportation, does the technical regulations, and they subcontract with organizations like the Association of American Railroads to enforce a lot of the technical standards and inspections. But there's no other economic regulator, and DOJ, Department of Justice, unlike in most other regulated or partially regulated industries, does not have authority to block a merger, for example. There is still some antitrust jurisdiction, but I think uniquely among banks, telecom companies, electricity companies, the DOJ does not have a separate authority to block a merger. We simply have to advise the STB on whether a merger might be anti-competitive or not.
And then not to mention, this is very much a federal area.
Oh, yes.
So do the states come in to try to not to block or maybe try to regulate in some way?
The earliest attempts to regulate the railroads, and we're talking now about 150 years ago, were by the states. And they passed some railroad regulatory laws attacking discrimination, long haul, short haul differences, things like that. But in the end, the Supreme Court ruled that these were unconstitutional interferences with interstate commerce. And at that point, it was left to the federal government, which created what I think is the world's first independent regulatory agency, the Interstate Commerce Commission, in 1887.
You mentioned earlier in our discussion that the railways' conduct that might have an effect on competition, such as how they set their rates, is regulated to some extent. How are challenges initiated if the railways don't like the outcome of such regulation? Are they brought against the regulators or the railways? I suppose shippers could also potentially challenge the outcome as well.
The shippers are the ones who challenge the outcome.
Okay.
In general, the railways have a lot of rate freedom now compared to what they had before the Staggers Act in 1980. So shippers have the ability to bring a rate case. There are different mechanisms for bringing a large rate case and a small rate case, depending on the size of the complaint and the damages. Almost all of the big rate cases have been brought by coal companies. I think maybe only one or two by grain companies, although in principle, again, other big bulk shippers like chemical shippers could do it. There are, in theory, 3 criteria that the shippers could use to challenge the rates under STB rules. They could say the railroad is inefficiently operated, so they shouldn't have to pay for bad management. That's never been used. They could say that the railroad is earning too much money. They should not have to pay high rates to subsidize monopoly profits. And that's just beginning to be used, and I predict will be the main basis of the next big rate case. The third way, and the way that it's virtually always been done, is say they should not be required to cross-subsidize other shippers. And that is another way of saying the use of the famous standalone cost test, which is, as I say, been used in every major rate case that I know. It's very expensive, time-consuming, makes a lot of money for a lot of lawyers and consultants, and has been increasingly criticized by the STB itself, both in their staff report and in the most recent decision, as saying, rate case decision, where the commissioners themselves said, look, there must be something better than this. This is not the way we should be evaluating whether rates are too high.
In plain English, conceptually, what is the standalone cost test? And if the STB's dissatisfied with it, why are they using it?
That's a fair question. The standalone cost test, and again, my international friends sometimes express disbelief at this. The standalone cost test asks the shipper to model what it would cost to serve them with a newly built railroad from origin to destination. If they're paying more than they would pay to a newly built railroad, then the rate is too high. A couple of things wrong with that. Well, a few things wrong, I would argue, with that test. First of all, it was created 40 years ago or so in the telecom sector to discourage inefficient bypass. Well, nobody is really worried now that there'll be too many freight railroad tracks built to get around the current system. But second of all, once you start saying, okay, let's build a model completely new railroad and see how much it would cost, then you are just delving case by case deeper and deeper into details. And literally there are debates in how much grain would be grown on land adjacent to this mythical railroad to ship on the railroad to help cover the fixed costs. How many bridges would they have? How large would they be? And as Chair Begeman said in the most recent decision, I'm tired of arguing about how many toilets are going to be built for how many workers. This is not a basis for whether a rate is too high. This is based on Fallhaber's old article on rates and inefficient entry. And it still has its defenders, although I will say they've been dying off. My good friend Bobby Willing was his last big defender, and William Baumol before him. But my good friend John Mayo at Georgetown, for example, still defends it as the best available way to calculate a rate ceiling.
What about small rate cases? I've heard of this concept called final offer rate review. How does that work, and why is there a distinction between small and large?
Good question. Well, the Congress has more than once directed the STB to craft a mechanism for smaller shippers to complain about their rates. Because the standalone cost test with all those economists and consultants and lawyers is very expensive, maybe $10 million to bring that case right now, according to various estimates. So Congress has directed the STB to come up with easier methods, cheaper methods. They came up first with something called 3 benchmarks, which looked at 3 different ratios of various traffic related to other traffic or measures of variable cost. That wasn't really used, so they came up with simplified standalone cost. That wasn't really used. So they have a third one now, as you say, called final offer rate regulation. It's like final offer arbitration in the sense that both parties end up giving their proposal for the correct rate, and not an arbitrator, but this time the STB itself must choose one or the other. There are many people who believe final offer arbitration, sometimes called baseball arbitration, is a way to get people to make reasonable offers as opposed to unreasonable offers where the arbitrator will simply split the difference. It is their legal challenge now by the railroads, who are saying that the STB does not have the authority to do that. It will be interesting if it's ever tried, because it's a completely new mechanism for the STB. The shipper and the railroad must file the shipper must file its complaint and also its proposal for the right rate at the same time. And the railroad, in a somewhat contradictory position, must also file its defense and its alternative rate at the same time. So it'll be interesting to see how that goes forward. I personally think the STB is very much to be commended in looking for a way to do small rate cases that will actually be taken advantage of by the shippers.
A very brief explanation. What's big rate versus small rate cases?
Oh, it's on the amount. It's just the amount of the relief demanded or requested. I think it might be $5 million, but I don't remember the details. But it's based on how much the shipper ships, the complaining shipper ships, and how much damages it's asking for.
So for the small rate challenge, we understand is an actual situation that's ongoing, right? So just to provide a little bit of background, in December 2022, the STB adopted the so-called final offer rate review procedure, right? To encourage essentially to have a more streamlined process or approach for shippers and railroads to resolve their smaller rate disputes. But so shippers, as what we've read, seems to have been welcoming the rules. Is that right? And why?
Yes. Well, they've been hoping that there will. They have not been using the existing 2 mechanisms, so they have been encouraging the STB to look for another mechanism that will work for small rate cases. And so I think shippers generally, whether this is the mechanism they would have chosen or not, I'm not sure, but they are like, as I just said, they are encouraging the STB and applauding the fact that the STB continues to try to get a good, useful methodology for small rate cases as an alternative to the very expensive methodologies that are used in bigger rate cases.
It's a case to watch, I guess.
Oh, I think so. Yeah. Yeah. I mean, the DOJ has filed encouraging the STB and saying, yes, they do have the legal authority to do this. The railroads have said the STB is supposed to set rates. It's not supposed to sit back and wait for two people to suggest something and pick one of them, because either one of those might be completely wrong. And the STB doesn't have the authority to pick a wrong rate.
Would you say, I guess on a very high level, such adoption of the rule is indicative of some long-term poor performance by railways in terms of how they provide services to shippers?
I would say, just based on my reading of the record at the STB and the news, that freight railway service has definitely declined over the years. As Wall Street has gotten more interested and more invested in the freight railways, they've all or mostly been adopting this new technique called precision scheduled railroading, which the shippers argue has resulted in the closure of facilities. It is certainly, or something certainly, during COVID, the railroads sharply cut back on their employment. Something like 25 or 30% of the class ones, according to Chairman Oberman of the STB. And of course, when you have very skilled laborers, it's hard to hire them back quickly when you need to resume service. And the railway demand returned pretty quickly, maybe more quickly than people expected. So I think shippers are very strong. And I think Chairman Oberman agrees, and others in the STB agree, that with precision scheduled railroading, with a new focus on Wall Street and private equity demanding that the railroads focus more on the bottom line, get those operating ratios down, that service has really fallen. And the STB is trying to do what it can, including but not limited to that switching order, to force the railways to get back into providing good service, because it's so important for the bulk shippers and for the economy, as Barry started off saying.
Since we do have a little bit more time, and people might be curious in this space in terms of railway, which is by its nature so large and very, very it's a space that's very natural to have, I guess, natural monopolies. What do you call? Are there still mergers and acquisitions happening? What we read is that recently in March 2023, the STB approved the acquisition of Kansas City Southern Railway Company by Canadian Pacific Railway Limited with conditions. So just briefly, anything unusual about this merger review and approval?
Well, it's the first successful application for mergers among the Class 1 railways, that is the largest railways, since 2000, when the STB announced tougher rules for mergers in the year, or 2001. In the year 2000, the Canadian National offered to buy the Burlington Northern Santa Fe. The ink was barely dry on the Burlington Northern Santa Fe merger. And the STB said, whoa, wait a minute, this is getting to be a very concentrated industry. This could lead to more mergers. We could end up with 2 or 3 transcontinental railroads competing with each other. And we don't like that idea, said the STB. So they put tougher restrictions on the Class 1 railroads merging, including not just saying there were no competition problems, but showing that there would be competitive benefits. And there was only one Class 1 merger proposed in the ensuing 20 years. The Canadian Pacific applied to buy the Norfolk Southern, and they ended up abandoning that, partly in the face of DOJ opposition to the independent voting trusts they were setting up. We argued that would reduce competition on its own. This merger that they had just allowed was unusual in that it was the 2 smallest of the Class 1 railroads, the Canadian Pacific and the KCS. The merged company remains the smallest of the now 6 North American Class 1 railroads. And it was pretty much a completely vertical merger, that is end to end. Unlike just about any other combination you can imagine among class ones, these two really did not compete with each other except at their junction point in Kansas City. And Kansas City is one of the most railway served, along with St. Louis and Chicago, cities in the country. So DOJ filed in that. There was a battle between Canadian Pacific and Canadian National to take over the KCS. We filed saying they shouldn't, as we had in 2015, saying they shouldn't be allowed to have an independent voting trust. The STB said, yeah, that's right for the Canadian National, but it allowed it for the Canadian Pacific. And so that merger, a vertical merger essentially, and we also reminded the STB, who may or may not have needed reminding, that vertical mergers can be harmful under certain circumstances. And that's very much part of the monitoring that the STB has announced going forward on this merger, to make sure that in this rare case where it has now allowed a merger of two class ones, that there would be no competitive problems, even on a vertical axis rather than horizontal.
On that merger, you made reference to the remedy, which, as I understand it, is 7 years in duration, which I think I heard was unprecedented in this space. But what's more interesting, to me at least, is that the remedy seems to cover a lot of things that have little to do with competition. And you said it was a vertical merger, and with behavioral requirements built into the remedy. Did DOJ say anything about the behavioral remedy, or was it okay with it?
In this case, we did not comment on the behavioral remedy. You know well that DOJ and FTC aren't big fans of behavioral remedies in general.
That's why I asked.
Yes. We filed saying the two proposed acquirers should not be allowed to have independent voting trusts. We filed to remind the STB that, contrary to some very old precedents that it had, that vertical mergers could indeed be harmful. We did not comment or file related to the remedies themselves.
One of the things that we talked about earlier was that the U.S. and Canada are, and I guess Mexico also falls into this category, are unique from railroads in other parts of the world in that they're vertically integrated.
What are your thoughts on vertically integrated rail systems?
I regard it as a benefit and a great arrangement for, and as you mentioned at the beginning, I've done a lot of discussions around the world about railway reforms. For a large country that ships a lot of freight, I think it's a great system. It's succeeded in attracting billions, tens of billions of dollars of private investment into the system every year. The European system, or the vertical separation or third-party access systems, I think make more sense if you're trying to create competition in a smaller country, especially a smaller country that has more passengers than freight, as in Europe. Although even in Europe, I'm sure people would tell me it's politically impractical. You could combine railroads from smaller countries into a larger European railroad that went from, Madrid to Berlin or something like that. And then it might make more sense. The problem, as I mentioned, with the European system is that the infrastructure is owned by the state or by a state-owned company. And every year when the railroad goes to the legislature and says, man, we really need some more money, the legislature says, yeah, we know that, but the pensioners need it too. And by the way, the military is getting out of date, and the tracks will last another year. And so they just, in general, the the railroads, the state-owned railroads, railway infrastructures have not been maintained and not acquired the investments that U.S., Canada, Mexico have succeeded in putting into the system. And so I think the challenge for those systems is to figure out a way to attract, all this private equity money that's washing around the world looking for returns. Let's figure out a way to get it into the Latvian or Ukrainian or any other country's railroad capital stock, because in those countries, just as in the U.S. and Canada, railways could take a lot of traffic off the roads with benefits for energy use, with benefits for pollution, congestion, but they just haven't had the support that they need. So I think in practice, that's been the weakness of the third-party access or complete vertical separation model in places like the EC.
One last quick question. I'm curious to get your thoughts on why people perceive the quality of service on Amtrak to be below the level that one might experience in Europe.
Well, Amtrak has the main disadvantage that it is operating in a railroad system where most of the traffic is freight. The railroads were all losing money on the passenger service they were required to provide until the 1970s. And so the government took it over. And for the most part, not exclusively, but for the most part, Amtrak trains, they're essentially a government-owned monopoly on passenger rail in the U.S., long-distance passenger rail. But for the most part, they operate on the tracks of the freight trains, the freight railroads. And so the freight railroads are required to give them access at marginal cost or avoidable cost. So, of course, the railroads don't like to do that. They fight it. They say they're not being paid enough. They say it gets in the way of their freight trains. And so the other thing to mention is that passenger trains around the world now lose money, because if you want to go a long distance, you fly. If you want a short distance, you drive. There's a sweet spot for rail, like DC to New York, for example. There's a longer, sweeter spot for high-speed rail. And as you probably know, there are some partially privately funded high-speed rail projects being built in the U.S., in California, in Florida, being discussed at least in Texas and the North and the Pacific Northwest. Amtrak is planning to increase the speed of its Northeast corridor trains. Amtrak is operating under a lot of constraints. And like most passenger rail in the world, it would not exist without subsidies. There's just not enough people who want to go long distances on trains. And so if governments want to have passenger rail, and a lot of members of Congress make sure that the Amtrak station in their little, state capital or county seat stays open, you've got to subsidize them. And Amtrak, as I understand it, only makes up its variable costs. Don't speak of its fixed costs, only makes up its variable costs on the Northeast corridor, nowhere else in the country. So governments around the world generally have made a choice. We like passenger rail for all the reasons I mentioned earlier. So we're going to either subsidize it, or in Japan, they do the opposite. They put huge tolls on the highways. So it costs you a whole lot to drive to Tokyo, so you take the train instead.
This has all been very helpful. Now, just to wrap up our discussion a little bit, we'd like to know you a little bit better on a personal level. Would you tell us something about you that people don't know if they just know you professionally?
Oh, they don't know that I play the French horn, and that when I was younger, I aspired and assumed that my career would be as a professional French horn player in orchestras.
Did you have a passion for trains when you were a little boy?
No. What happened is interesting, I think. When I got assigned my first couple of train cases at DOJ, and started getting into I knew nothing about trains. I started getting into the business. And what I decided was that railways raise a lot of the same issues, very interesting economic issues, as more glamorous industries like telecoms and electricity. And in railways, the topics had not been nearly so well examined. So, the standalone cost test, for example, everybody knows how it works in telecoms, but they don't have a good understanding of how it works in railways, or at least they didn't until my article. And now I hope they do. But yeah, that was the main thing. Very interesting questions that were less well examined than in telecoms and electricity, for example.
That's all very interesting. And then for people who are perhaps younger or junior, they could be economists or young lawyers, or even students who are interested in doing what you do or close to what you do. Do you have any advice for them?
Well, to be effective in working on the railway sector, whether on the private side or the government side, as far as I know, you need an advanced degree. So a PhD in economics is a great thing to have. There are some people who don't have this who are very good. But in general, you would want to get a PhD in economics, which means as an undergraduate, taking all the math you can, or get a law degree or a public policy degree. But yeah, get an advanced degree. Engineering, of course, if you want to work for the FRA. But these are high level debates now. I think, despite what people were fearing around 40 years ago, I think this industry is not going away. Unlike that famous song, The City of New Orleans, that said, they got the disappearing railroad blues. I don't think the railroads are going anywhere. I think they're going to stay important and, get a law degree or a PhD in economics or engineering, and you can contribute to this really interesting and important debate.
Well, thank you very much, Russell. This has been very helpful. We usually, this is also, I would note, a little longer than our usual episodes. This is because usually we think you would listen to our program on your regular commute. But if you're commuting via Amtrak, the length of the show might be appropriate.
Right.
Until next time, thank you for listening.
Russell.
Thank you. It's my pleasure. I appreciate the invitation.
Thank you for listening to this week's episode of Our Curious Amalgam, a competition, consumer protection, data protection, and privacy law podcast. It is produced and shared around the globe by ABA's Antitrust Law Section. The opinions expressed by the participants in this podcast are their own and do not necessarily represent their employer or other organizations. If you like what you heard or would like to become a member of the American Bar Association, please check out what the Antitrust section has to offer at ambar.org/antitrust. You can learn more about our podcast at ourcuriousamalgam.com. If you have comments, suggestions, or podcast ideas, please reach out to us at podcast@ourcuriousamalgam.com. Until next time, thank you for listening.